Hello, and thank you for tuning in to another episode of All Out Nevada, your go-to podcast for insightful glimpses into the Nevada judiciary. I'm your host, Seth Beasley, representing the Supreme Court Nevada Administrative Office of the Courts. Today, we're bringing you a special episode. I'm joined by none other than Chief Justice Douglas Herndon of the Nevada Supreme Court. We are going to be diving into his experience transitioning from a single department judgeship to one of 7 justices shaping the legal landscape from the appellate bench. Justice, thank you very much for joining me today.
Thank you. It's a pleasure to be here.
To kick off the conversation, can you perhaps tell us about your time as a trial court judge? Where did you preside and what type of cases did you hear?
So I was first appointed to the bench in 2005 by Governor Gwynn, had been in the district attorney's office prior to that. And when I first took the bench, my caseload was all civil for the first 2.5 years or so, which was a big change because I hadn't really done anything from a civil law standpoint since law school, and I had been an attorney for about 15 years. So that was a big change. After 2.5 years, I inherited a split docket where I heard criminal cases and civil cases. I did that for about 10 years. And then in 2017, I took on an all-criminal docket when I started the homicide team, and that pretty much continued on until I left the bench in 2020 when I got elected to the Supreme Court.
Okay, so before I get to my second question, what was the homicide team?
So starting in 2008, I believe, I became the chief judge of the criminal division of the court down in the 8th Judicial District. Mm-hmm. And over time, as we constantly were evaluating what we were doing, how we were doing it, and was there a better way to build a mousetrap, so to speak, one of the things that we kept noticing was the increase in homicide cases. And homicide cases were spread out amongst all the different judges that had a criminal docket. So probably 20 plus judges handling homicide cases. Judges who all had varying backgrounds and varying degrees of experience handling some very complex cases, essentially. And we noticed that there was kind of a huge delay in getting those cases to resolution, an ever increasing delay, whether it was by settlement or by trial. So as part of a commission that had been put together by the Supreme Court, there was a group of us, Steve Wolfson from the DA's office, representatives from the public defender's office, independent private defense counsel, et cetera, got together and put a proposal. And one of the proposals was to create a homicide case team in the 8th Judicial District, which would take the pending 360 homicide cases, of which about 56 were death penalty cases, and consolidate them all into a team of 4 judges to handle all of those cases and kind of bring a little more consistency and hopefully efficiency to how those cases were handled. And ultimately, we got it off the ground and started it in 2017.
That's very interesting. So that's something that's still
ongoing.
Oh, cool.
Still have the 4 judges down there that are handling them. And it's probably one of the only things that I've ever dealt with in the justice system where every single entity was on board with doing it, and every single entity seems to be very happy with how it's worked out since we started it. And by that, I mean the judiciary side of it, the DA's side of it, the public defender's side of it, special public defenders, prison, jail personnel. Everybody seems to think that it's done a tremendous job of getting those cases streamlined, getting them to resolution quicker. If people are going to get on probation, they're going to get on probation earlier. If people are going to prison, they transition out of jail earlier. And you have a more consistent approach because there's only 4 judges doing it. And part of when we created it, one of the mantras was the judges have to kind of do things in a very similar way so that the attorneys have some predictability. That doesn't mean you give up your autonomy to rule on motions and issues and sentencing. But we all agreed that if there's a plea deal, we're going to follow the plea deal. We all agreed that we'll hear calendars in a certain way to give flexibility to the attorneys that need to appear on those cases and so on.
That's a fascinating topic. I would love to talk about that more sometime. So since being appointed to the bench in 2005, you went on to lead several initiatives, including serving as chief judge of the criminal division and later creating the court's dedicated homicide case team, which we just talked about. What motivated you to take on these leadership roles and what were the biggest challenges and rewards?
Well, in terms of instituting changes and taking on leadership roles, I would hope that anybody that becomes a judge is doing it in part because of your perception of things that are occurring within the justice system that you think may be you could have a voice on and your experience would benefit to making some changes. I'm not an advocate of changing just for change's sake, right? There has to be a need for it, but I don't think you become a judge and just kind of isolate yourself into your calendar and you're doing your thing and everything's great. You got to look at the broader picture of what are we doing as a collective, and is it working, or are there things we should be doing differently to make it work better? So when I first became chief of the criminal division, it was with that idea that, I spent 15 years as a prosecutor. I tried a lot of cases. I appeared in front of a lot of judges. What are things that we could make changes to kind of do better? Where do we need new stuff? While I was the chief of the criminal division, I think we instituted our veterans court, for instance. We knew how successful drug court had been. We had a DUI court functioning at that time, and specialty courts are very beneficial in the criminal realm. And so veterans court was a big deal. Looking forward towards the idea of the homicide case team, things of that nature. So I was very pleased with all the things that we were able to do, and I think you're just constantly revisiting how are we doing it, and is there a better way to be doing it, and seek to make those changes where you can.
Through those projects, through those initiatives, what were some of the biggest rewards?
The biggest rewards were when you could... At the end of everything you do as a judge, at the end of every case, at the end of every decision you make, at the end of every policy you institute, are people that are going to be affected by it, right?
Right.
And so your hope is, that some of the things you're going to do are going to have an adverse impact on people. If you have to sentence somebody to prison, it's not just that person that goes to prison and suffers because of that. You're going to have families that are going to deal with difficult issues because a loved one goes to prison. Depending upon how you treat a criminal defendant, you're going to have victims' families that are going to suffer consequences because of that. So at the end of everything you do, there's people that are going to be affected. And so when you're looking at making changes, it's kind of with that in mind. And when they work out the way they're supposed to, that's terrific. Like with the homicide case team, not only did it create efficiencies, which people on the victim side appreciated, right? That cases are getting to closure quicker.
Right.
And actually people on the defense side appreciated that as well. Most people that are charged with serious crimes don't want to sit around in jail forever. They would rather either have their case adjudicated and get out, or if they're going to go to prison, it's kind of a better place to be in the prison than it is in the jail. Additionally, I think over the first year that we were in business, we saved the county over $1 million in terms of the efficiency with which the cases were being handled and adjudicated. And so when you see all of those things kind of falling into place, that's very rewarding, obviously.
Makes sense. And that's one of my favorite things about doing this podcast is just hearing about all these different things that judges prioritize, the projects and specialty courts.
Right.
It's great to know there's that kind of leadership in the judiciary. So kind of shifting gears a little bit about your transition into the appellate courts. I'm curious, what was one of the biggest surprises or adjustments during your transition?
So let me back up for just a second. One of the things you asked me a minute ago was what was some of the difficulties in district court. And one of the biggest difficulties down there, and it'll play into what I'm going to talk about here, is when you're running a division of the court and you've got 32 judges, sometimes it's like herding cats, right? Everybody is independent and autonomous and individually elected. And even though we all have to have the idea that we're a collective, everybody is also wants to make their own decisions on things. And that can be very difficult, getting everybody onto the same page at times or getting harmony with things that you want to do. When I moved here, one of the most pleasant things was that even though I was entering into a collective where there were 7 of us making decisions, not just for the court, but on individual cases. And that was a big change from being individually autonomous in your decision-making as a trial court judge. But when I got here and entered into that collective, there was a part of me, and I'm sure everybody else would say the same thing, where you wonder, how is that going to play out? It played out swimmingly from the beginning. And I think that's kind of a testament to the people that we have on the court, that we had at that time and that we have now. The ability of everybody to be good listeners, right? To respect the opinions of everybody else and what their experience is, revisit their own opinions when necessary, and make that decision-making process pretty easy, because that can be a very big adjustment if you're very strong on, well, I'm right about everything and everybody else is wrong, and that's just not going to work. So moving from I make all my decisions by myself and I'm responsible for those to now I have to make decisions with 6 other people was a big change. And I don't think that I thought it was going to go badly, but it was really pleasant how well it went and how easy it was to kind of move into that.
That is really interesting. And I do have some follow-up questions about that in particular. But first, I was curious. So how do you think your time as a trial court judge has impacted your perspective when reviewing appeals from lower courts? How has this perspective served you during your time?
For me, right, and look, there are people that come to the court having not been trial court judges, and that's not just a Nevada thing, that's all over the country. But for me personally, that was invaluable. I was down in the district court for 15 years in the civil criminal division. And as I said, I had an all civil docket, I had an all criminal docket, I had both. I was involved in settlement conferences and civil cases and criminal cases, involved in the administration of the court. All of those things kind of give you information and data as you're kind of evaluating how to do things. And you pretty much, if you spend 10 plus years down there, you're going to see just about everything that comes into the court. And you also learn a lot about how the attorneys practice. To me, that was very big, right? There's custom and practice to how attorneys do things. And the judge can't just kind of arbitrarily set themselves and their preferences over how the attorneys have grown into how they're going to do their business, right? You need to have some respect for that. And so when you get up here to the appellate court, one of our primary responsibilities is reviewing what district court judges do. And so having spent as much time down there as I did, like I said, that was invaluable to me to feel more comfortable in the role of evaluating what district court judges do, because I did that for a very long time. And I know the inherent difficulties in having very large caseloads and having to work through those cases and move them along with some efficiency in addition to being effective.
That makes sense. I can see how that perspective would be really useful. So regarding your time as a trial court judge, are there any aspects of that you miss in particular?
Oh, many.
Yeah.
So when you come to the trial court bench from having been a trial attorney, there is that certain amount of, well, I really miss being a trial attorney now, because you're sitting as a trial court judge and you're watching good attorneys try cases. And that was something that I did for a very long time and I enjoyed. And then as I got more comfortable with being a trial court judge and the role that I had there, I became a big lover of that too, right? And I really enjoyed watching that process unfold and being the referee and kind of being in court with attorneys, whether it was in calendars or in trials. And so then you move on to here, and now it's a whole other type of refereeing, but it's refereeing from a distance without a lot of interaction, right? We're in a pretty solitary job here where you have limited court time and a lot of reading and conferencing and deliberating and discussing and analyzing, trying to fine-tune everything to get it exactly right, which is important, but I miss very much being in court. I enjoyed having calendars every day, being in trial as much as possible, and just the interactions of cases actually being litigated like that.
Right. I can see that. That would be a big adjustment in itself, I'm sure, from having people in front of your bench all the time to what you're doing now.
Yeah, I remember when I first became the presiding judge of a panel here, it was, I think, Justice Perigary, Justice Lee, and I. So it was a couple of years ago. And I said, we're going to set a whole bunch of cases for oral argument. Come on, we need to argue more cases. We need to be in court more. And Justice Perigary is like, hold on, we can't do that. You got to understand how the time works and the time to get all these things disposed of, et cetera. It just doesn't really work that you could set 10 cases for oral argument one day. And so I learned very quickly that, my... I guess my appetite for doing that was not the wisest way to approach that. So we had to pull that back a little bit. But I think it kind of came from my desire to be in court more and interact with attorneys and watch them argue cases. And I just enjoy that process a lot.
Hi, everyone. I hope you're enjoying this episode of All Out Nevada. We're always striving to bring you valuable insights and education, not just for judicial officers, but for anyone interested in the Nevada judiciary. If you find our content helpful or intriguing, please share your experience with your friends, family, and colleagues. Your support helps us reach a broader audience and ensures more people can benefit from our discussions. Thank you for listening and supporting I'll Allow It Nevada. Okay, so kind of circling back a little bit to the collaboration aspect. So how do the demands of collaboration differ as one of 7 justices compared to working as a trial court judge? Can we expand on that just a bit more?
Yeah, I mean, as I said, when you're a trial court judge, you can talk to other judges about issues that you have, but they're not making the decision. At the end of the day, you've got to make that decision, and you've got to be comfortable doing that. You can't, well, I'm going to wait. You know, people want to have their cases get to some closure. They want to move on. They want to get a decision, both litigants and attorneys. And so you have to be as prepared as you can be, and then make that decision as efficiently and quickly as possible to get that moving forward. We have a lot more time here to be able to go through and evaluate things, do research, do searches around the country for other states, whether they've dealt with issues, because we're not in court every day having to rule on a motion that just happened in court, which is very nice. But also from a collaboration standpoint, I think that it's kind of an attitude and approach thing. There's nobody that goes into our deliberations with any type of ego about being right or wrong. It's just, we all want to get it right as much as we can.
Right.
And so if somebody has something to offer maybe you didn't think about, then you go back and revisit what your initial opinion was. If any of us feel like, you know what, I need a little more time because I want to research some issue that just came up while we were discussing this, then we're going to give grace to each other and find the time to do that so that we know that when we can get a decision out, it's been as well thought out as possible.
So how do you approach the responsibility of being a justice, especially knowing your decisions may set precedent and guide future legal interpretations?
So I never dreamed of being a lawyer when I was a kid. Okay. I went to college to be a marine biologist. My goal in life was to be Jacques Cousteau. Jacques Cousteau is probably a little old for you, Seth, but for us 60-year-olds, he was like a world famous French marine biologist, right? And I wanted to sail around the world studying sharks and coral reefs. So I spent 2 years in college doing that before I ultimately decided to make a change for a variety of reasons, mainly that my career counseling office kept telling me I was going to go work for like an oil and gas company in a lab or whatever. And that wasn't my vision. So I knew that I had an aptitude for reading and writing probably better than the hard sciences that I was taking anyway. So I ultimately decided to go to law school. And it wasn't necessarily with the idea of ever practicing as an attorney. I just thought it would be a very good education to get. I tell you all this because I feel blessed every day by the opportunities that I've had. And I've loved every job I've had as a lawyer, right? Both as a prosecutor, a district court judge, and then in this role, because I never saw myself being here. I mean, there's a lot of time that I had imposter syndrome as an attorney, and then as a district court judge, and then as a Supreme Court justice. So for me, every day I feel grateful that I have this opportunity to do what I do, and I feel a huge responsibility to kind of do it as best as I can, right? Where you're spending all the time you can and focusing on the things that you need to, because the people of the state deserve that kind of dedication and perseverance and openness and humility from people that are going to serve in this role.
I think that's important. Yeah, for sure. And that's very interesting. You know, I wanted to be a marine biologist.
Really? Well, there you go.
It's a popular thing, I think, for youth. What doesn't sound nice about being by the ocean all the time. So going back to appellate work, what do you think are some common misconceptions about appellate work?
From the public standpoint, I would think that they view appellate work probably just cases being argued, right? Because that's probably all they really hear. Supreme Court heard arguments today in such and such. The United States Supreme Court heard arguments today in this case. So they don't really have a great understanding that that's the tip of the iceberg and everything else under the ocean is massive. So the misconception would be, in my mind, the amount of time and effort that goes into everything else that's occurring before a case gets to oral argument or ultimately to a decision. That's all of the effort that attorneys have to put into building the record when they're down in the trial courts. making sure that the things that are necessary to good appellate decisions are put into the record that comes up to the appellate courts. And then our evaluation of not just what attorneys file in terms of briefs on a case, but our evaluation of all the appendixes that are provided to us that have the record in it, where we're going back and reading transcripts from trial, motion practice in the trial courts, all of that stuff to have a good understanding. Sometimes I feel like we go into court knowing people's cases better than they know them, because sometimes attorneys can change and take over cases. I wasn't the trial attorney, but I'm the appellate attorney. And I feel like we have a pretty good grasp of their cases when we get to that point of oral argument, but there's a whole lot that goes into getting to that point. And I think it's important because a lot of times people have asked me, how can you only give 15 minutes for an oral argument? I mean, how is somebody supposed to argue their case in that much time? And that's when I say, let me tell you everything that happens leading up to that, right? All of the record building and the briefing and everything that they do and that they read from the other side and that we do and that we read from everybody. So you should be able in 15 minutes to hit your high points and explain things in a way that highlights what you need us to know separate from everything else.
So you mentioned that 15-minute and everything that goes into it before that. And I'm sure there's huge variance, but
Sure.
what is like a typical timeline for like a case before the appellate bench?
What is a typical timeline?
Yeah.
Those are very hard to judge because, like in a criminal case, or let me start with a civil case. In a civil case, when an appeal gets filed, it's going to automatically go to our settlement conference program.
Okay.
And only if it's inappropriate for that program would it be kicked out and then get back on to a timeline of getting the briefing done. If it's in the settlement conference program, that can go on for many, many months. But once a case is ready for briefing and we set an order for briefing, that sometimes gets continued by the parties. I need a little more time. We don't have the transcripts yet from the trial. We're having a problem with a court reporter, whatever it may be, right? And attorneys will oftentimes file things with us saying, hey, we have a motion pending in the district court to revisit an issue here, so we want to hold off on this appeal proceeding right now. So some cases may take 3 years, some cases may take 1 year. Once it's ready for us to decide, meaning they've got all their briefing done, we pretty much get it in front of a conference within weeks or get it set for oral argument within a month or so. And then once the case is argued, generally speaking, within a few months, we're going to get a decision out. Sometimes it may take a little more time than that. So the point of that is that there are various parts of that timeline,
Right.
some of which are out of our control, some of which are solely within our control. And so they can expand or shrink the timeline.
Before ending this, I did want to ask, because I know civics education is something important to you. So can we just touch on why is it important and what keeps you engaged in things like public education and community outreach?
Did you take civics in high school?
Yes.
Be honest. Okay. It seems like that's a fading thing in a lot of school curriculum, the idea of civics and government, such that there's a lot of people that don't really have a good understanding of how government functions, the three branches of government, separation of powers, and the importance of the independence of each of those branches of government. And that can be very difficult when you're in a role like I am with the judiciary, and you're partly overseen by the legislature that decides your budget. You're partly overseen by certain things the executive branch does, but you then have to pass on things that the legislature does and pass on things that the executive branch does. So I think the more informed the general public can be about government and civics, the better off we all are. And I've just had I don't know whether it's the luck or the curse over time to get invited a lot to come out and speak to groups about that. And regardless of what the nature of the group is, every time I've gone out to talk about it, it's been terrific, right? With people kind of being engaged about it. And sometimes they'll say, we didn't have a government class when I was in high school. I didn't do civics any longer. And I didn't know about this, or I did hear about that. How has this changed? It's really been very rewarding. From just a general standpoint of being involved in community stuff, there's just certain things that I fell into in various ways that became very important to me and very rewarding, separate from doing the job of an attorney or a judge. I've been teaching at it's called the Signs of Hope Rape Crisis Center down in Southern Nevada. And I started teaching there in 1997, I believe. And you're just teaching the volunteers that come in, get taught various things. And what I was teaching about is the court process, so that they know how to talk to people about what's going to happen when they go to court. And so they have people talk about law enforcement process, hospital process, everything. And so I've been doing that for, what is that? Almost 30 years now. When I was a district court judge, in part because of the civics issue and things that I perceived, I started a mock trial program for kids. So we had kids come in third grade and fourth grade and then eighth grade, and they did mock trials. And they would actually, starting in third grade, they would also watch actual criminal calendars to kind of understand that process. And then they would put on their own mock trial. They were the attorneys, the judge, the witnesses, the jury. And I had a script for them that I wrote that was based on Harry Potter, right? So it was kind of Harry Potter's illegal use of magic, something that was very topical for kids back then. And still today they like it because Harry Potter's still popular. What can you say? And then in eighth grade, it was a mock trial about the assassination of President Kennedy, as if Lee Harvey Oswald wasn't killed himself and went on trial. And so they had to develop their own questions. I wrote all the police reports and all of that, witness statements, but they then had to produce a trial on their own, taking in all the information about the competing theories of how Kennedy was killed and whether Oswald was guilty or not guilty. And it was very rewarding because it got a lot of kids interested in law. I've since sworn in as attorneys kids that I did mock trials with when they were very young, which is really neat. But it was just also eye-opening for them about government and how things happen, and being as open as we can with the judicial branch to explain that to them. So I like that. And then there's other things that just if somebody invites me to come speak, I'll go 100 times out of 100, whether it's out of the law school or anywhere else, because I think the more that judges can engage with the community, and we're kind of limited. We can't just talk about anything, right? We can't commit on certain topics, but I think it humanizes the judicial branch, and that's difficult for a lot of people because we cannot talk about topical things like politicians, that they feel like we're sitting in an ivory tower and they can't really relate to us. So the more that judges get out and do things and just say, hey, we're all human beings here. We're all doing different jobs. We all have different life experiences, but we're all people.
Right.
I think it's good for our branch of government to do that.
And to your point about civics education, I do vaguely remember that, but the judicial branch is kind of neglected. I feel like it's more about the...
But that's the most important branch. Yeah. Come on.
All right. So as we round out the conversation, so I do want to know, so what might be a highlight or one of the most rewarding parts serving as a Supreme Court justice?
I think people, right? It's a people thing. And that can be a kind of a cliche answer, but when you're a district court judge, you've got a staff of 4 or 5 people, right? You got an executive assistant, you got a law clerk, you got a court reporter, you got a court clerk, and those people work in your chambers. And because there's so much going on every day with your court calendar, that's pretty much who you're seeing every day, those 4 or 5 people, because you're doing your calendars, you're doing your trials. Every so often there's a judge's meeting and you'll interact with some other people, et cetera, right? Different here. You get a much bigger opportunity here to work with a much broader spectrum of people, whether it's you doing this podcast, working with Phaedra Kalicki and her staff attorneys, working with Elizabeth in the clerk's office, working with Catherine and everybody in the AOC, particularly now as the chief. I get to kind of go out and see how the sausage is made in all these different aspects of the court that really aren't just about deciding cases or hearing cases. It's about the whole function of the court system and what we do, helping everybody around the state, right? And I never cease to be amazed at the quality of people that we have working here doing all these things. When you're a justice that we have really great people because things are working really well and things are getting produced and we're doing a good job. But you walk around and actually visit with people and see what they do and see how they do it and have meetings and talk to them about it. And it's very, very rewarding to know that there's those kind of folks working for the government and the judicial branch.
It's amazing.
Yeah.
So
they make me look good every day, right? Seriously. I mean, people, you're the elected as the judge or justice, But there's a village of people that are making you either look good or look bad, right? In terms of how they do things. And I think people around here make us look tremendous.
You know, as someone working for this agency, it's a privilege to work under such great leadership and important initiatives. It's very motivating.
Good.
So last question I have is, what do you think the public should know about the Nevada Supreme Court that they may not fully appreciate?
Not every Supreme Court is built the same.
Okay.
And I think that in a lot of aspects and a lot of places around the country, politics have entered into things in ways that are unfortunate with the judiciary. Not here. Mm-hmm. And I'm not just saying that. And as sincerely as I can convey that, there has never been an occasion in the 4.5 years that I've been here where I felt like somebody's political views, and everybody has political views, right? I mean, everybody, whether you're a justice, a judge, a podcast producer, a staff attorney, a banker, a doctor, whatever it is, we all have views on issues that we see, and people will couch those as political views. That has never into anything that we've done. People have philosophies about how to interpret law, which is fine, but this is a very hardworking group of people that are very independent, and I don't think any of us care to be involved in politics or have politics infect what we do. When I gave the State of the Judiciary speech, I was talking about the fact that I have a distant relative, my 8th cousin once removed, who was a gentleman named William Herndon, who was Abraham Lincoln's law partner. And he wrote a letter 150 years ago and quoted a number of things about Abraham Lincoln. And he talked about him being the most decent man he had ever met, and that his view of work in the law was that it was noble duty, nobly done. And I have said that repeatedly over this year as the Chief Justice, that I want judges to embrace that. And I think everybody on this court does. They work hard. They don't let the views or the dissatisfaction with things with the U.S. Supreme Court or anybody else infect what we do on a daily basis. So if that was something that I could convey to the public about the goodness of the people we have doing this job and how hard they work at it and how fair and independent they are, that would be it.
You know, I think that's an amazing place to leave off, you know?
Okay.
Chief Justice, thank you so much for joining me. I very much enjoyed our conversation.
Been a pleasure. I appreciate you inviting me. Thank you.
Thank you. A heartfelt appreciation to our guest and to everyone who has tuned into this podcast. Before we wrap up, here are a couple of quick, important reminders. For continuing legal education credit, be sure to complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. If you have any questions, topic suggestions, or comments, we welcome your input. You can email us at jepodcast@nvcourts.nv.gov or submit your topic ideas through our topic suggestion form linked in the episode description. We value and look forward to hearing from our listeners. Stay tuned for more episodes of I'll Allow It Nevada. This is Seth Easley signing off. Take care, Nevada.